Hi, folks. Welcome to Profiling Evil Reacts and this review of the continued sealing of the Barry Morphew arrest affidavit. Now, yesterday, June 4th, Patrick W. Murphy of the Chaffee County District Court issued his ruling on the release of the Barry Morphew arrest affidavit. And it isn't the news we were hoping for. Now, I'm going to break down the judge's order in this video and we'll explore what's next. But would you please just take a moment and hit the like and the subscribe buttons? Ring the bell so that you get notifications on videos like this one. And please, if you get a chance, go through and look at Lauren Scharf's coverage of this case on Fox 21. I think she's done just a great job on this. Now, let's talk about the judge's order. In the judge's order on motion to limit public access to Barry Morphew's arrest affidavit, which was, if you remember, filed back on May 5th, the judge started off by indicating that the people, that's the prosecution under the direction of Linda Stanley, as well as formal requests by the media and Profiling Evil, I might add, is the reason behind his ruling on this request. He started by recounting the rule of law in this matter, which says that the court records in criminal cases like this one are presumed accessible to the public, but access could be denied by the court. Now, in order for the court to deny the release of the affidavit, the courts must be able to say that they believe that it's important to withhold the information, including any redaction that they do, for the integrity of the case. Now, Judge Murphy referenced a number of cases wherein the record was withheld to protect certain parties, including privacy interests of individuals who might be negatively impacted by the release of the record. The judge specifically called out a defense argument in this case that they believe several substantial interests exist which support limiting access of the arrest warrant affidavit, basically not making it available to us. These substantial interests are preventing the release of inflammatory information contained in the affidavit. Things like he's wanting to protect the alleged victims, the Morphew daughters, and not have ongoing defense investigations impeded by what may happen. He also believes it preserves Morphew's right to a fair trial by finding impartial juries from the surrounding community. Now, the court found the nature of the affidavit and the protection of the Morphew daughters as a motivating reason to keep the document secure for a while longer. The court mentioned its concern about the length of the affidavit, some 130 pages, and he remarked that by far this is the lengthiest and most detailed affidavit that he has ever seen in the 30 years of experience he has with criminal cases. Now, Judge Murphy also said that a significant amount of the information in the affidavit, in his opinion, wasn't relevant to the court's finding of probable cause and possibly would not be admitted under the Colorado rules of evidence at trial time. As you look through this form, you'll see that there are a lot of redactions in the form. And frankly, the judge is saying that he just thinks a lot of this wouldn't be allowed into court. Bottom line is that the judge feels that having the information from the affidavit in the public eye could hamper Morphew's ability to prepare his defense. Now, the judge specifically called out his concern that he doesn't want the release of the affidavit to be the cause of any harassment, intimidation, or anything like that for the victims, Mallory and Macy Morphew. He also talked about their right to be treated with fairness, respect, and dignity, and who can argue that? I think the judge showed a great deal of compassion as he spoke of the unimaginable situation the girls have been placed in. They lost their mother, and now they're having to deal with their father being charged with their mother's murder. But they need time. The kids need time to figure out how they're going to deal with everything and how they're going to deal with things if they continue to reside in the small community of Salida. Murphy went on to talk practically in the document, stressing that simply redacting a 130-page document is going to take a lot of time, and it needs the consensus of both the prosecution and the defense. Additional time is going to allow the parties to review and understand all the information. So in the end, the judge flat out denied the release of the affidavit and any investigative notes from law enforcement. Now, the district attorney argued that the law that Judge Murphy is leaning on was not even in effect when the May 5th affidavit was filed, and frankly, it shouldn't be used. She went on to argue that the affidavit only includes the information needed to establish probable cause. Well, the new defense team for Morphew argues that in their opinion, the affidavit includes much more than is required for probable cause. So the judge pulls a wild card, in my opinion, and he reminds the state it's their legal responsibility to assure victims and witnesses of crime are not harassed, intimidated, or abused. Murphy said he feels that at this time, keeping the affidavit scaled back serves a substantial interest in protecting the victims in the case. Murphy then went on to address the media consortium's response that, in their opinion, Morphew's right to a fair trial would not be compromised by the release of the affidavit, and it's, in their opinion, in keeping with the integrity of the Fourth Amendment. Well, while Murphy agreed that the information in the search warrant was not necessarily prejudicial, the amount of prejudice is relevant and is more significant given the length and the breadth of the affidavit. Holy cow, what must be included in this thing? The court concluded that the arrest warrant affidavit will remain sealed and suppressed from public view until 7 days after the conclusion of the proof of evidence presumption great hearing and the preliminary hearing, which are currently scheduled to be completed around August 24th. Hey, we're not out of the woods yet, folks. Before the court will expire the order, though, they are going to hang on to the opportunity to consider further requests or arguments as to why or why not the order should continue, and frankly, in what form. So there you have it, folks. We're going to have to remain patient while the wheels of justice slowly grind forward. I hope you found this helpful. And here's a question for you. Do you think the court will release the arrest affidavit at the end of August? Do you think it contains any real earth-shattering information? I'm going to look forward to reading your comments down below. And thanks for supporting us at Profiling Evil. Thanks again, and we'll see you soon at the next crime scene.